Welcome. Today we have Mary Tang. She has over 30 years of experience representing creditors. She's also a board member of the section, and she's going to be talking about automatic stay considerations. So I'm just going to turn it over to Mary, and like I said, questions will be at the end, so you can put them in chat, but we'll get to them at the end of the program.
Right. Thank you very much, David. Hello, and welcome to this program on the automatic stay and how it interacts with evictions and foreclosures. And as Corinne Bielski told the bankruptcy section this morning, the Contra Costa County Board of Supervisors did not extend the no-fault residential eviction moratorium and COVID-related commercial eviction moratorium. So those provisions will be ending September 30th. We'll see what happens after that. I hope that you learned some new things today, because I definitely learned new things preparing for the program, especially involving the changes to non-judicial foreclosure bidding. That's quite some interesting stuff. I will be taking questions at the end, as David said, and you can submit those questions through the chat function. The written materials that you'll be provided with have all the bankruptcy code and case citations. So if you find yourself trying to write something down that's on the PowerPoint, don't worry, that is going to be coming to you soon. And I wasn't sure how many of the participants aren't readily familiar with bankruptcy law. So I'm going to give a brief explanation of the automatic stay, just in case there may be one or two. But we're going to be going pretty quickly through this. So if you need to review written materials later, if I've gone too quickly, you're also welcome to send me an email in the future to get some background. So when a bankruptcy case is filed, an injunction called the automatic stay is immediately imposed against creditors to stop them from taking action against the debtor or the debtor's property. So if you think of it as a wall that pops up, and so the creditors can't get through to the wall to get at the debtor or debtor's property, so that way the debtor can get a little bit of a chance to organize debts, and certain creditors don't get an advantage over others. The automatic stay stops foreclosures, evictions, repossessions, lawsuits, wage garnishments, and even threats from creditors. And creditors really want to avoid doing anything that would violate the automatic stay because of the penalties associated with those violations. For one thing, actions taken in violation of the stay are void. So if a judgment is entered or a foreclosure occurs after the bankruptcy case is filed, they basically never existed. The creditor would need to redo those actions after it gets relief from stay. The debtor can also ask the bankruptcy court to order the creditor to pay the debtor damages for such a violation. And that would include actual damages, attorney's fees, and possibly even punitive damages. So creditors need to be very careful that they don't violate the stay. I'm going to shift now to the PowerPoint presentation. Okay. I'm going to just concentrate on the PowerPoint as opposed to having my face appear throughout this program. So I hope you don't miss me too much. Today, we're going to be discussing a variety of scenarios in relation to residential evictions, non-judicial foreclosures, that new SB 1079, the post-foreclosure bidding changes. And we're also going to talk about some of the basic ideas for relief from stay where sometimes the automatic stay will terminate early or not go into effect if there have been multiple bankruptcy filings. Also, there can be in rem relief when a real property secured creditor is entitled to relief that sticks with the property for up to 2 years. And sometimes a creditor is entitled to annulment, where the bankruptcy court essentially erases or annuls the automatic stay after a bankruptcy is filed, and that validates whatever action that the creditor took that would otherwise be a violation of the stay. So we're going to start with residential real property leases. So we've got a story, and the story is that John is a tenant who's behind on his rent by several months. His landlord files an unlawful detainer case in state court, and if John files bankruptcy, what are his options? If the landlord has already obtained a judgment for possession in the UD case before John filed the bankruptcy, then the automatic stay doesn't stop the landlord from proceeding with the eviction. So the concept here is that due to the judgment, John has been divested of his legal and equitable possessory rights that would otherwise have been protected by the automatic stay. Note that this just means that the landlord can proceed with eviction. He could not enforce a money judgment. There is an exception. The automatic stay will remain in effect for 30 days if John files with his bankruptcy petition and serves on the landlord a certification that under applicable non-bankruptcy law, there are circumstances under which he'd be permitted to cure the monetary default, and very importantly, that he's deposited with the bankruptcy court any rent that became due or will become due during the 30-day period after the case is filed. So he has to deposit that money, and it has to be the full amount of the rent, not just his portion of the rent. And the clerk should be issuing something to the landlord, whose name hopefully was provided with the bankruptcy petition, that says, hey, we got money. If that happens, then he gets an extra 30 days after the bankruptcy case is filed where the stay is protecting him. If he wants that stay to remain in effect during the bankruptcy, then within that 30-day period, he has to cure all the arrears and then file a certification that he's done so. So that would be all the money that's due under the judgment, that judgment for possession. If he does cure that, then the Bankruptcy Code 362B22 doesn't apply, and this automatic stay remains in place and prevents him from being evicted, unless, of course, he ends up defaulting, and we'll hope that everything works out if he's able to get that money together. If he says the first thing, saying I deposited the rent, the landlord can contest that. And if he says I cured everything, the landlord can contest that, and the court will conduct an expedited hearing on that. There are official forms which help with this. 101A is something that would be filed with a petition where he states exactly what he needs to state. And 101B is filed within 30 days in which he says, I cured everything, it's all good. And those are attached to the end of your materials, but most of you probably use those. Other considerations are what if the UD case is appealed? The BAP considered this in an unpublished opinion in Nicholson and said basically that the landlord must obtain a final non-appealable judgment for possession prior to the debtor's bankruptcy filing. This is different than state court. So it may be that they just were not aware that in UD cases, eviction is not automatically stayed upon appeal. The tenant would need to make a motion pending appeal in the state court. So that would need to be granted in order for this to be stopped, this 362B22. Also, the Ninth Circuit held in re Pearl under a little bit different circumstances, but the same concept, that no occupant of the premises, that means those who were tenants or visitors, retains any possessory interest of any kind following service of the writ of possession. So it's pretty clear that there's protection there for a landlord who gets that judgment. Also, I have a little comment there. Does the co-debtor stay matter? In another unpublished case, the BAP talked about the co-debtor stay, but it seemed kind of a silly point because a landlord is obtaining possession of his own property, not an action to collect a debt. And in a co-debtor stay in 12 and 13 protects individuals who are liable on debts with the debtor. Finally, those two, I mean, the provision for 362B and 362L, those apply in all chapters. What happens if the landlord does not obtain judgment for possession before the tenant files? If John files a Chapter 7 and makes no payments, then his landlord can file a motion for relief from stay to evict him. And any rent that was due at the time the petition was filed is discharged. If John moves out, then the landlord can't collect post-petition rent. But if John stays without paying, then there is at least one case that says that he may be liable for post-petition rent. But that's where he's sort of staying and not paying and causing trouble. If John files a Chapter 7 case and does make post-petition payments, he may be able to work something out with his landlord. But the landlord has to be careful that it doesn't require John to pay pre-petition arrears. So that's something that if you're making arrangements, don't say that he's liable for those pre-petition arrears. If John files an 11, 12, or 13 and makes post-petition payments, and makes no post-petition payments, then the landlord should file a motion for relief from stay. But if the lease hasn't terminated, John can assume the lease and John can stay the eviction by curing the rent arrears through his plan and maintaining post-petition rent going forward. So Chapter 11 or 13 cases filed and John starts making payments on his post-petition rent, then the landlord has to see what the plan provides for. If the plan doesn't provide for him to get payments, then the landlord can object and then may want to go forward with a motion for relief from stay or may work something out with John. If the lease default is based on endangerment of property or use of illegal substances, then there is a procedure for a landlord to obtain relief from stay without filing a motion. Essentially, the landlord has to file and serve a certification about the debtor's bad acts, which need to be pretty recent. The debtor can contest that, the court would hold a hearing, and if the landlord prevailed, he can proceed with eviction, and if the tenant prevails, then he's protected by the stay. Okay, now the new and different non-judicial foreclosure bidding procedures. So we've had some changes to the law. Some of you may be aware of them. Effective January 1st of this year, and for a 5-year period, the legislature has changed what happens after a foreclosure sale. I think it would help to understand the intent behind the legislation so that you can help, that can help you make a better sense of it. The new law is intended to support home ownership by individuals, not investors. So California wants individual people to own their own homes, and that's going to make for a better California, not investors who may be using the properties to rent out. And essentially California law does not like that. The new law gives certain categories of individuals or nonprofits a leg up in bidding or bidding after the fact at these foreclosure sales. One class of bidder is favored: the person who intends to live at the property. A second class is disfavored, and that would be an investor. If at a foreclosure sale, the favored buyer, who is referred to in the statute as the prospective owner occupant, if that new owner is the last and final bidder at the foreclosure sale, then he will most likely not be subject to the post-bidding deal that the disfavored buyer has to deal with. So prospective owner occupant is the high bidder. He has to provide the foreclosure trustee with an affidavit saying, number one, he's going to move into the property within 60 days. Number two, he's going to live at the property for at least a year. Number three, he's not the former owner or related to the former owner. And number four, he's not acting as the agent for someone else. So if the high bidding prospective owner occupant submits this affidavit, then the trustee believes it and says, okay, here's the trustee's deed, go ahead and record it. And the trustee's deed, if it's recorded within 18 days of the foreclosure sale, which is different from that 15 days that we're used to, and you're going to see why in a few minutes. If it's recorded within the 18 days, then the sale is deemed perfected as of 8 a.m. the date of the foreclosure sale. And that's under the Civil Code 2924 HC. So that whole protection most of us are familiar with, which essentially protects a buyer who has purchased at the sale, and if a bankruptcy is filed somewhere before that 18 days is over, yet the trustee's deed gets recorded within 18 days, then the basically the wall does not stop the perfection of the sale. So that's all if the favored buyer is, that's all if the high bidder is the prospective owner occupant. And now we get to the disfavored buyer. The investor, the large corporation, I think they got like Blackstone and things like that, that did a lot of bidding during the Great Recession, ended up with a lot of property that other people weren't able to come up with. So that disfavored buyer could be an investor, corporate owner, or even the original lender if there were no bids. I'm going to refer to this one as the LLC investor just because it's easy. So an LLC investor submits the high bid at the sale. After the sale, it's not over. In the past, it was deemed to be over, but the LLC investor can be outbid after that sale by certain select individuals or entities. One of these groups is called the eligible tenant buyer. So the person or persons who are living at the property, the tenant, not former owner, can submit a notice of intent to the trustee saying, I am going to match that high bid. And will need to match that high bid within the next 30 days. So it's, you have to have a lot of money if you're going to be the eligible tenant buyer. But he only has to match the high bid. The next group of potential buyers is this eligible bidder. And the eligible bidder is a little less favored. I hate to use that term considering it, they are really favored. The eligible bidder can be a person who intends to live at the property. So just like that potential owner occupant, this is a person who says, hey, I'm going to live at the property in 60 days. I'm going to stay there for a year and I'm not related to the former owner. So that's one person who fits the eligible bidder category who was not living at the property. Also, there are nonprofit organizations that could be eligible bidders, governmental entities that are going to potentially improve the lot of that property. So rather than it being used for investment purposes, it's going to be hopefully brought back into the hands of an individual homeowner. So the LLC investor places the high bid, then these two categories have a chance of bidding after the fact to get the property for that foreclosure sale price. So here's the process. Within 15 days of the foreclosure sale, an eligible bidder can submit a notice of intent, and I'm combining eligible tenant buyer with bidder just because it's easy. 15 days of the foreclosure sale, they submit a notice of intent to place a matching bid. And they submit that to the foreclosure trustee. They don't have to do an affidavit saying, I really, really will do this. Essentially, they just say, hey, I intend to do this. And then boom, magically, there's an extra 30 days that's added onto the foreclosure sale process. If no notice of intent is submitted by the 15th day, the trustee will issue the trustee's deed to the LLC investor, who will then need to record it within 18 days of the sale date to receive that protection, 2924 HC. But if the eligible bidder does submit a notice of intent to place a bid, then the trustee is going to put the process on hold for 30 days to give that eligible bidder the chance to submit the bid, meaning produce cash or a cashier's check. If the trustee receives the cash or cashier's check, and maybe there may be more than one eligible bidder that's submitting these, and of course, that'll be interesting to see what happens when there are multiples. But anyway, if the trustee receives that by 5:00 p.m. on the 45th day after the sale, then the trustee will issue the trustee's deed to the eligible bidder. And then they need to record it within 3 days in order to get the protection of the civil code. So that's why earlier we said 18-day, and then there's 48 days if it's gone all the way through to this process of there being a bid. If the trustee doesn't receive a bid, but did receive that notice of intent, so the trustee doesn't receive a bid by the 45th day after the sale, then the trustee will issue the trustee's deed to the LLC investor. So keep in mind the 18 days is either that first prospective owner occupant, they have to record within 18 days, or the LLC investor, if the LLC investor doesn't have anybody submitting a notice of intent to bid. The 48 days comes into play where someone has submitted a notice of intent. Maybe the bid comes in, maybe it didn't. And I talked to several trustees and they said, oh yeah, we're receiving notice of intent, but we're not receiving the bids that follow. But we'll see what happens after that. So what happens when a bankruptcy case is filed affecting this situation? The civil code says that a non-judicial foreclosure of real property is basically deemed final when the auctioneer accepts the final bid. Well, we know that that's a little bit skewed by this new process. In our new scenario, Jane D is in default on her home loan. Her lender scheduled the foreclosure sale, and so Jane files bankruptcy to prevent or delay the sale. Okay, we're going back to the wall idea. If Jane's bankruptcy case is filed before the foreclosure sale occurs, then boom, the wall pops up and the automatic stay stops the foreclosure sale. As we know, they sometimes go forward anyway, but it means that the foreclosure sale is void. So she files her case at 9:59 a.m., sale takes place at 10 o'clock a.m., foreclosure sale is void. The lender would need relief from stay in order to conduct the sale all over again. If her bankruptcy case is filed after the foreclosure sale occurred and the new owner records the trustee's deed within 18 or 48 days of the foreclosure sale, then the sale is deemed perfected as of 8 o'clock on the foreclosure date. The buyer would file relief from stay to make sure that it gets a clean bill to go forward with this. And the relief from stay is warranted under the civil code and the Garner case. If Jane's bankruptcy case is filed, okay, that's all if the deed is recorded within that 18 to 48 days. If her bankruptcy case is filed after the foreclosure sale, but the trustee's deed is not recorded within that 18 to 48 days, generally bankruptcy courts are still going to find that the sale removed her equitable right of ownership and that cause exists to lift the stay. There are some cases that I put in the materials where there were long periods of time. I think one was 5 years where there may be some reason to say, well, wait a minute, we're not going to go forward with saying that there's cause in this case. So there can be some extenuating circumstances. In this case, the buyer is not only going to want relief from stay, but they're also going to want to annul the stay. Because that bankruptcy was filed after the foreclosure occurred, and the deed was not considered to have been perfected as of 8 o'clock p.m. on the foreclosure sale date. So the creditor needs to, or the buyer needs to erase that. And that's what the annulment would be. If Jane's bankruptcy case is filed after the buyer has recorded the trustee's deed, if Jane doesn't leave the property, the buyer still needs relief from stay because she retains a possessory interest. So for post-foreclosure evictions, we've got a new guy. Foreclosure sale has been held, title perfected, but there wasn't a bankruptcy case that interrupted things. So this wasn't Jane filing bankruptcy as the former owner. Instead, someone who's living at the property, Jim D, is not paying rent to the new owner after the foreclosure sale has occurred and the title has been perfected. So Jim's not paying rent, the new owner files a UD case, and Jim files bankruptcy. If the new owner files a motion for relief from stay because Jim's not paying rent, then it should be fairly straightforward to obtain relief from stay under those facts. But if there was a valid lease in place and Jim was paying, then the new owner would be honoring that. If, and here we go back to this Pearl case I mentioned earlier, if the new owner obtained a judgment for possession and a writ of possession, the Ninth Circuit found that Jim has no legal or equitable interest remaining in the property. So essentially you're filing a motion for relief from stay, citing to this, and it makes the judges happy because that way they could just keep pointing to this case and they can say, there's nothing I can do about it. There's nothing I can do about it. We like happy judges. And then finally, in this last situation, sometimes you get a number of occupants. They may be filing multiple bankruptcy cases. They could be removing the case to removing the state court UD case to federal court, and basically just preventing the new owner from taking possession. This is not something where the in rem relief under 362D4 works. And we're going to talk about that later, but most people are familiar with that as something that a real property secured creditor gets. Instead, the new owner, to stop these multiple bankruptcy filings, would need to file an adversary proceeding and get injunctive relief. And so just so that you'll know, this is different. Filing a motion isn't going to do it in a post-foreclosure eviction situation. Okay. Moving on to subjects which may be a little bit more familiar to people. Automatic stay based on multiple bankruptcy filings and how they, sometimes the stay is in effect for just a short period of time and sometimes it's not in effect at all. I'm going to try to point out a few things that you may not have been as aware of. When a debtor files bankruptcy initially, the first case, the automatic stay remains in place as to property until the bankruptcy case is closed, dismissed, or a discharge is entered and the or denied and the property is abandoned. So for number 3, that last has to be both. A common mistake, which sometimes judges make, is that they think that when the debtor receives a discharge that the stay is terminated. But this discharge terminates the stay only as to the debtor, not as to property of the estate, and the trustee may still want to administer assets. So be aware of that. So that's first case. So what if that first case is dismissed? Well, if that first case was a Chapter 7 and it was dismissed under 707B, which has to do with a presumption of abuse, if the second case that's filed is a case other than Chapter 7, then the automatic stay just sticks around. But if the second case is filed and the first case was pending within the same year that the second case is filed, then the automatic stay terminates as to the debtor on the 30th day after the second case was filed, unless the debtor files a motion to extend the stay, and the hearing is held and the motion is granted within that 30-day period. So that's usually that's something that only debtors' attorneys know to do, as you know. Okay, so the critical language here is that it says that the statute says the stay terminates as to the debtor. It doesn't say anything about property of the estate. And case law goes both ways on how to interpret this. The Inri Reswick case is one that involved a Chapter 13, which held that the stay terminated as to the debtor and the estate. So both lumped together in that Chapter 13 case. Whereas Judge Klein in Inri Tu Dao, that was a Chapter 7 case, and it was held that the stay only terminated as to the debtor. So be careful. Make sure that you know, or it may be that you're going to want to get relief in order to find out from the judge what that judge's thinking is. I think Zorzolo has something on his website that says, I only believe it terminates as to the debtor. So be careful when you're acting with this second case pending. The idea that the Chapter 7 trustee may want to sell the property, makes it seem as though maybe that's what the drafters had in mind, but they probably didn't. Okay, and then finally, where you've got a third case pending, and you've had a first case and a second case that were pending without a 707B issue, the automatic stay does not go into effect upon the filing of the third case. The debtor can file a motion to impose the stay and demonstrate that the third filing was in good faith. Okay, on to in rem relief from stay. And as you may recall, the term in rem means against a thing, and the thing here is property. So the idea that the stay holds onto the property based upon whoever else may try to file bankruptcy helps to know that it's sticking to the property. We just talked about bankruptcy cases that were filed by the same person over and over. In this scenario of in rem relief, it could be that a husband and wife or others will alternate bankruptcy filings. So that way you don't have that automatic, the terms that the second case filing only gets 30 days. The third case gets no automatic stay at all. Instead, you've got multiple people who are filing, and the bankruptcy code sections don't apply to that. So the bankruptcy code does allow a secured creditor who's secured by real property can get relief from stay as to the property itself under certain circumstances. If the creditor can show the judge that the filing of the bankruptcy case was part of a scheme and that it was intended to delay or defraud or hinder creditors, and essentially, if they're filing bankruptcy and it postpones and gets in the way of creditors, that's pretty easy. Part of a scheme, again, they filed bankruptcy. Hard to say that that happened inadvertently, but this last part, did that scheme involve a transfer of ownership of the property or multiple bankruptcy filings affecting the property? So transfers of property can mean a person who owns the property gives percentages of the properties to people who then go and file bankruptcy cases. So that's a transfer of a property. And those were popular for a while back during the Great Recession. The multiple, so that one is one that's kind of easy if there's been a fractional interest or if the owner transferred it to his son or something like that. There's also a practice that some have done where the owner of the property transfers the interest or an interest in the property to a person who's already filed bankruptcy. So we call those hijacked cases. The debtor who's in bankruptcy may not even know that the property was transferred. So if you see something like that happen, you want to call debtor's counsel, if possible, to say, hey, did you know that somebody's expressed, saying that there's an interest in the property, and usually the attorney will cooperate with you, and just as long as you say, hey, it's not the debtor's fault. Those three items must be proven in order for the judge to find that in rem relief is appropriate. And once you get an order granting this, that order must be recorded in order to be effective, because it has to provide notice. The idea is that anybody who gets one of those fractional interests should be given the opportunity to check the county records and see that, oh my goodness, there's an interim order. That means that this property is not protected by the bankruptcy stay. So those orders are usually good for 2 years, but the debtor in a case can move for relief from the order based on good cause. And on to annulment. And here, if a creditor obtains retroactive relief from the stay, then there's no violation of the automatic stay. So no penalties would apply and the action would be deemed valid. So in order to obtain annulment, and this is actually something that is sometimes happens where a debtor files bankruptcy without telling the creditor. It may get then the creditor forecloses and the creditor doesn't know about the bankruptcy, and then the case gets dismissed and the debtor gives up. But a month or 2 down the line, the creditor finds out what happened and says, hey, I didn't know about this day. I should get this annulled so that the sale can be validated. So the creditor files a motion and the bankruptcy judge then reviews the situation. The motion is to annul the stay. The bankruptcy judge reviews the situation to determine whether or not annulment is appropriate. So there are different things to be considered. Just say that the debtor didn't tell the lender that he'd filed the bankruptcy before the sale. The lender holds a foreclosure sale, but no one bids. So the lender ends up as the owner. And then the debtor says, hey, I filed bankruptcy. The new owner filed a motion for annulment and asks the judge to get rid of that automatic stay. And the judge says, well, I need to look at the equities involved to determine whether or not it's appropriate to keep things as they are or to put the property back in the debtor's hands. And if the judge thinks that, well, in this case, if I say that the automatic stay is in effect, it just puts the lender back in the same situation as it was in before, and that preserves the status quo before the bankruptcy. I'm okay with that. But if the debtor, on the other hand, has been engaged in delay tactics, the purchaser of the sale is a BFP, maybe they paid $100,000 over the opening bid, and the debtor didn't reveal the bankruptcy case for a few weeks, the judge may say, oh, in this case, the equities favor annulling the stay because there's going to be money available for distribution or money available to the prior owner. And the debtor was involved in some devious actions and should have told the creditor what was going on. So the general trend is to look at, did the creditor know about the bankruptcy petition? And number 2, was the debtor engaged in unreasonable or inequitable conduct, or that prejudice would result to the creditor? And that's where if it's a BFP, one might say that there's more prejudice, whereas if it's the original lender that ends up with the property, maybe it's not so much prejudice. The court also may analyze other factors to examine the debtor's and the creditor's good faith, prejudice to the parties, and whether or not it's practical to annul the stay. I am not going to go through these factors, but just know that there's a list of, we'll say a non-exclusive list of things that the judge may consider in figuring out whether or not the equities favor annulling the stay. something that I mentioned earlier, where the creditor finds out about the bankruptcy filing after, a little while, and didn't know about it. The bankruptcy case got closed. People went about their business. So now the creditor finds out, oh, there was a bankruptcy filed and I didn't know about it. The Ayong case, Aheong, states that the bankruptcy court retains jurisdiction to annul the stay even after the dismissal of the bankruptcy case. So you wouldn't need to reopen the case in order to file a motion for annulment. But you may want to cite that case in your brief just to remind the judge, because sometimes they'll be saying, why didn't you reopen this? I think I'm a little bit behind on my slides. All right. And then finally, and I've moved through this at a rapid pace. Finally, some miscellaneous items. I think in the past, people might have thought that if a bankruptcy case was filed and a BFP purchased the property, that there was some special dispensation for BFPs, but no, just being a BFP who purchases a property at a foreclosure sale after a bankruptcy case, that's not an exception to the automatic stay. This may factor into the analysis of the equities if annulment is requested. Also, if the trustee's deed is delivered but not recorded, there's a conclusive presumption that the sale is complete as to a bona fide purchaser. Sometimes there will be a case where bankruptcy case is going along, it's dismissed, maybe for failure to file documents. And there's a period of time during which there's no bankruptcy. And then a week, 2 weeks pass, and then it's reinstated. So if the debtor's case is dismissed, then reinstated, then the automatic stay is reimposed as of the time the reinstatement order is docketed. In the sample case, the debtor's case had been dismissed. It filed a motion to reinstate the case, which was granted, but in the meantime, the lender had conducted a foreclosure sale before the order reinstating the case was entered on the docket. So you've got dismissal, foreclosure, and then reinstatement. But the reinstatement order had not contained language to retroactively impose the automatic stay. So the court said, reinstatement order did not reimpose the automatic stay retroactively. And then finally, and this is the final comment before we get to the question section, there was a recent US Supreme Court case where they did not like nunc-pro-tunc orders. They made it clear. But that was a case that was not involved with the Bankruptcy Code. The Bankruptcy Code contains language which allows annulment, which is nunc-pro-tunc relief. It's going back in time. And so in a recent case, the Ninth Circuit found that nunc-pro-tunc relief is allowable during bankruptcy due to the specific language in the code allowing annulment. So I'm going to stop sharing the screen and allow there to be questions. I'm not sure. There we go. I do not see. Okay, let's see. I see some chat. I don't see any questions popping up. Is there a question and answer? Oh, here's a question. Yay. So if the debtor fails to list an item of real property and the corresponding foreclosure action on the debtor schedules, is the law still that the debtor is barred by judicial estoppel from pursuing the wrongful foreclosure action? I don't know. I have not dealt with that. Let's see. I don't know. Sorry. If somebody else knows the answer to that, then I would appreciate it. Any other questions? Anybody excited about the next 5 years of?
Well, I wanted to let everybody know that next week, actually tomorrow, I take that back. Tomorrow, we're having a kind of an information session about how you can become attorney of the day to help with any landlord tenant issues. This has to do with, you know, some of eviction issues and things. If anybody's interested, I know it's not bankruptcy, but please go to the website and look at our program for tomorrow. And trying to find the title of it, and sign up and see if you're interested in getting more information about potentially helping out with that. That was just my little plug. But any other questions from anyone for Mary?
Feel free to reach out to me if you have questions. And also the trustees, I just want to say, they're just going crazy with this new law. It is, they're not getting paid anymore, but their liability is, what are they going to do with the property for 45 days? Who's going to keep it safe? Who's going to insure it? So lots of interesting things to be considered for this new one. And they're trying to clean it up a little bit. They're trying to get the legislature to clean it up since there are holes, and it will probably end up not helping the people it's supposed to help, which is very sad. That's it.
Okay, you'll get the materials that Mary sent me, and we will be able to get those out to you in the next day or so.
And I had a question. I'm happy to send out the PowerPoint slides as well as the whatchamacallit. I already sent the written material, so I'm happy to have Ann send those out